this is Danu, and I just wanted to pop in for a quick update on some of the things that we had talked about previously on the Facebook page. So first thing is that there has been a lawsuit filed, as I had predicted, on the prevailing wage increase. So let me kind of go over what's going on with this prevailing wage increase situation. The first thing is that there are actually two rules. So this is why people are getting confused, because I think sometimes people talk about it like it's one rule that's changed. There are two rules. The first rule is that there is a change in the prevailing wage with the Department of Labor. That change has already occurred. That is already active. That happened the day it was announced. Now, the second rule is that they are changing USCIS rules. That has not occurred, and they are giving 60 days for that. Now, USCIS is changing more than just the prevailing wage. USCIS is actually changing the definition of specialty occupation. What is the biggest change with USCIS? They're going to issue, for any individual that's hired through a third-party employment, they're going to issue the approvals for H-1s for only 1 year at a time instead of 3 years. That's one of the changes. The second change is connected with the definition of specialty occupation. It is minor changes and major changes, and the weight changes are enormous. What is happening and what was predicted is that this was kind of a last-ditch effort, before the elections, before the presidential elections that are happening in November, to try and get some anti-H-1b, anti-immigrant legislation or rules, if you will, through. So this is not actually a legislation. This is executive orders, and they're trying to get them through without going through the full process of review, without going through the process that is normally followed before they announce major changes in policy. And they're doing it kind of in a rushed way. So it makes me think that it's an effort to try and get these changes through before the election. There was predictions that there would be a lawsuit filed, and there is a lawsuit filed. So we have now to wait and see whether within that 60 days when the USCIS rules kick in, whether there will be some preliminary decision by the court to pause the effect of that new rule. Now, as we have seen kind of in the more recent months, especially since the pandemic, H-1b holders and H-1b applicants have been under a constant attack by the administration to try and curb the numbers of applicants, to try to discourage people from applying. And to a large degree, it has worked because H-1b numbers have really chilled out. People have lost jobs, people have returned, people have gone back to school. But I think that, as we sort of turn the year, there may be some changes connected with new administration, connected with a change in the situation with the pandemic and the vaccine and all of that, a change in the travel restrictions around the world, and also the whole ban on, remember the executive order banning consulates issuing visas for H-1s? Likely that is also going to stop being in effect. They cannot enforce it forever. So there will be a change coming up. And I think these next 2 to 3 months are really important to watch. Now, other news that has happened is around prevailing wage. Some people have, already found out prevailing wage has increased tremendously for anyone who is filing I-129, with the exception of H-2b applicants and R1 applicants. Everyone else, including H's, including I-140s, they are all going to be subjected to the increased prevailing wages. The prevailing wage, the increased premium processing fees. The premium processing fees were $1,450. They have increased to $2,500. So it is a very significant increase, and it is in effect probably going to discourage people from choosing premium processing. Now, a little bit more about premium processing in case you don't know. Premium processing is one of those government fees that an employer or employee is allowed to file. Most government fees by law should be paid by the employer only. However, when it comes to in the H-1b, I-140 situation, premium processing fee is the only fee that an employee is allowed to pay. So that has also experienced a tremendous increase. Now, another thing that has happened, and this has shocked everyone in the month of October, is that EB3 priority dates for people who have already filed I-140s, PERMs, and they're with their current employer, the EB3 priority dates have jumped ahead tremendously. So that's exciting for anyone who maybe is an EB3. Give us a call. We're doing adjustment of statuses for anybody who qualifies under the new priority dates. Also, anyone who's an EB2 who wants to maybe consider dropping to EB3. We're able to do that. Now, the difference between upgrading and downgrading, let me talk about that, like EB2 to EB3. If you're in EB2 and you're going to EB3, you're downgrading. The great thing about downgrading is that you don't have to refile the PERM if you're still with the employer who filed your EB2. You do have to refile the I-140. That can be premium processed, but now with the increased premium processing fees. But you don't have to file the PERM to downgrade. To upgrade, you do have to file the PERM and the I-140. So if you need to file the PERM and the I-140, you may not be able to take advantage of this big jump in priority dates. November bulletin is not out yet, but quite possibly we will not see this kind of a jump hold up in November because of the number of applicants that filed in October. So if you have a chance to file, or if you're just on the cusp of being able to file, get your applications in, the I-140s in as soon as possible. And, we can help you with that. Our number is 312-854-7065. Again, that's 312-854-7065. We also work with employers. So if your employer is open to working with us and has, no other immigration attorney, or is open to having you choose your immigration attorney, it is a really big advantage to choosing your immigration attorney, because you have just a better connection with the attorney, and you're able to relay your information in a more succinct manner, and you're able to rely on the attorney for better communication. So if you would like to give us a call, we're happy to talk to you. We're happy to talk to your employer and talk about how we can maybe file those adjustments if your priority dates are current. And, for anybody else watching, if you have any questions, we're happy to do a consultation, and give us a call. Again, 312-854-7065. My name is Denu. I'm the attorney here at SwagatUSA, and you guys are all welcome to call. Thank you.